accession to the Convention 108. Argentina has become the 54th state party to the Convention 108 and the third Latin American country to accede to it, following Uruguay and Mexico. Undoubtedly, this is a landmark in Argentina's data protection law. Convention 108 is not only a substantive regulation of personal data and its processing, but also an effective and powerful framework for international cooperation, which provides solutions for cross-border cases. Most recently, Argentina has formally initiated the process to sign the protocol amending the convention, better known as Convention 108+. The agency is certain that this new version of the treaty, which enhances the level of protection provided by the original text, will be incorporated soon to our national law. Second, the adequacy process. Since 2003, Argentina has been considered an adequate country by the European Union. After the GDPR, Argentina started with the officials of the EU the new process that is under review right now, as Bruno Giancarelli explained this morning. So we hope to finish this process soon. We heard what Bruno said in the morning. We already sent many reports, and we are still in conversations with the officials of the European Commission in order to maintain the adequacy of Argentina. Third, a new data protection law. Technological changes that have taken place during the last 18 years, as from the enactment of the National Data Protection Law in October 2000, together with the new international legal context, principally with the adoption of the EU Data Protection Regulation, have driven the agency to elaborate in 2016 a draft bill to reform the current law. The draft bill was partially modified by Argentina's president, Mauricio Macri, and then submitted to the National Congress in September 2018. The bill is intended to provide a high level of data privacy, adapting to the new international standards on data protection and, at the same time, enabling further innovation and investment in Argentina. In its current version, the major features of these new regulations are the following. Extraterritorial scope of the law. Similar to the GDPR, the national regulation would apply to controllers established in foreign jurisdictions when, first, an international treaty prescribes so, second, the processing of data is related to the offering of goods or services to Argentine data subjects, and third, the processing is related to the monitoring of behaviors, actions, or interests of Argentine data subjects. Free speech protection. The law will not apply to media, press, and journalism in general when they are processing data while exercising free speech. Media and press are subject to the law if they are not exercising that particular right. For example, if they are processing data to offer goods or services in their websites. Legitimate interest. The legitimate interest of the controller and/or third parties are considered a legal base that authorize data processing whenever the interests of the data subjects are not significantly affected. New rights. The bill includes new rights for data subjects, such as the right to data portability and the right to object automated individual decision-makings on similar terms to those in the GDPR. Underage data subjects. Pursuant to the Convention on the Right of the Child, the draft bill includes special rules and standards to protect the personal data of children and teenagers. More legal basis for international transfers. The consent of the data subject is explicitly recognized as a legal base that authorizes international transfers.